Good morning and welcome to the 294th District Court. My name is Chris Martin. I'm going to call this morning's criminal docket. When you hear your name, please say present or here. Isaiah Madrano. Maria Malicio.
Your Honor, she's outside sitting on the bench.
She's the one with the mask. Go ahead and bring her in and just tell her to sit in the back by herself. Gina Prox. Is it Gina or Jana? Gina. Hannah Hampton. Hannah Marie Hampton. Mr. Nicholas. Yes, sir. Is your client Mr. Hampton, or I'm sorry, Miss Hampton here? Hannah Hampton? Okay. Jaquavian Jackson. Present. John Johnston. Matthew Powell. And Lisa Holdren is appearing via Zoom, and she is on Zoom at this time. All right, is there anyone whose name I've not called? Do you have any counsel that's ready? Mr. Schmidt, are you ready? You ready on Ms. Holdren? Yeah. Good morning, Ms. Holdren. Can you see and hear me okay? Can you speak at all? Okay, so I don't hear you at all. Okay. Okay. I hear you now. I can hear you. I can hear you. Your microphone doesn't pick up well, so if you want to be heard, you'll probably have to disconnect that and use something else perhaps. But all right, this is cause number CR23. You're going to need a microphone. CR23-53, State of Texas versus Lisa Counsel Holdren. I believe we're here today on Ms. Holdren's motion for continuance. Ms. Holdren is appearing via Zoom with court permission. The court has reviewed the defendant's motion for continuance. Is there any objection by the state?
Your Honor, state would be opposed to the motion to continue, just as far as I know, she's not set first on the trial docket, but in case the state has to reach to a backup case.
Mr. Schmidt, you want to argue your motion?
Judge, I think at this point, I would rest on the motion. I would also submit defense exhibit A for the purposes of the continuance hearing, which are some medical documentation from Ms. Holdren's current issues.
And any objection to the court conducting an in-camera review of any medical information provided by the defendant?
No, Your Honor, state's had a chance to review it and no objection.
Okay, so it doesn't need to be sealed or anything or in camera?
No, sir, I just didn't want to file it with papers because it is confidential.
Okay, then the court finding that there are no objections, the court admits defendant's exhibit A.
Sorry.
Mr. Schmidt, do you know how long this condition is expected to continue?
Judge, based on my conversations with Ms. Holdren, that she's supposed to follow up for some additional tests, and I think she could clarify that if she could speak, but I think those are imminent.
Ms. Holdren, are you able to address?
Yes.
How long?
I can.
Go ahead.
I talked to my doctors yesterday, and they can't get me in until the 11th. So I have to go back to the emergency room. They did a culture on my neck, which I have strep.
Okay, I appreciate it, Ms. Holdren. All right, I can see that you're in pain. All right, the court, considering the Exhibit A evidence and the motion, the court's going to grant the defendant's motion for continuance. We will reset Ms. Holdren for the next jury selection docket, which will be, let's move her to December. I'm sorry, we'll set her for November 18th. And we'll see if this condition clears up by then. If not, then I'll entertain another motion.
Yes, sir. And can Ms. Holdren be excused from Monday?
Yes, Ms. Holdren, you're excused from Monday. You do not have to appear. The next time you have to appear is on Monday, November 18th. Okay, and just shake your head. The court finds that Ms. Holdren is
Yes.
acknowledging in the affirmative that she understands. All right, Ms. Holdren, you're free to go. You're welcome. Good morning, Mr. Manning.
Morning, Judge. My apologies.
It's okay. You ready on anyone or do you need time?
Yes, Judge, I believe you have a couple of weeks. If you'd like to do Ms. Hampton.
Ms. Hampton? I'm not sure that Ms. Hampton was here. I think Mr. Nicholas was stepping out in the hall to check on her.
Okay. And then, Mr. Powell, my show is here from Chamberlain.
Matthew Lee Ryan Powell, CR 24219. Mr. Powell, come on forward. Mr. Powell, go around. It's all right. I know it's your first time in here. Go around and then you'll come up to the podium with Mr. Manning. Thank you for not moving the rope and just walking on through. Most people have done that, so. Sir, who are you talking to? You're not talking to him, are you? Sir, you're not talking to him, are you, sir? Are you, sir? You're not talking to him, are you? No, sir. You're not talking to him like that in this courtroom while I'm trying to do a hearing. You're not going to blurt out what's going on in your life, are you? You're not going to do that, are you, sir? Put your hand down and listen to what I'm telling you. You're not going to do that, are you, sir? Then shut up and sit there. If you got something to say, go out in the hallway. Or wait, put your hand down and listen to me. We're not in your living room and this is not Walmart. And we're certainly not at McDonald's and you're not going to have it your way. You understand? If he tells you to do something, you do it. You understand? Yeah, and then you're back talking to him like a child as he's walking up. Aren't you? You waited till he got 10, 20 feet away from you with his back turned and then you had something to say. Keep your mouth shut or I'm going to hold you in contempt of court. I'll put you out in the jail and we'll figure out everything else later. Understand? Mr. Manning, I'm sorry.
No, it's fine, Judge. This is Mr. Powell. His name is spelled correctly. He understands the charge against him as well, the range of punishment. This plea is not guilty at this time. He requests to be set on pre-trial.
All right, court enters Mr. Powell's plea of not guilty into the record. Finds he waives the formal requirements of arraignment. Court sets Mr. Powell for pre-trial hearing Do you want to do December 3rd? Is that enough time?
Yes, Judge, that should be fine.
All right, court sets Mr. Powell for pretrial hearing, December 3rd at 9 a.m. Do we already have pretrial release papers on Mr. Powell? We did. All right, so Mr. Powell, you've signed your conditions of pretrial release. You understand what you're supposed to do? And more importantly, you understand what you're not supposed to do? Okay.
Judge, may I make a copy?
Sure.
Hey, Mr. Copy.
Yes, you're free to go.
Judge, I have some paperwork on Mr. Johnson. Additionally, I have some things to talk about with Mr. Jackson. We may have a couple of minutes.
Okay.
Oh, your man approach.
Yes, please.
This one.
Ms. Melicio, come on back here, Ms. Burrington, she'll help you.
I go this way.
Yes, ma'am. Ms. Prox, you're requesting a court appointed attorney, aren't you? Okay, we're gonna let Ms. Abraham get that paperwork to me and then we'll review it, okay, so. Mr. Madrano, come on up. Oh, I'm sorry, you're also requesting court appointed attorney, right? All right, I'm sorry. Let me review that paperwork and I'll be with you in a moment. Are we having a hearing on Mr. Jackson at all? Do we know? Are we having any contested hearings this morning?
I don't believe it's contested, Your Honor. Mr. Jackson, that was that kind of unusual safety discharge that Mr. Manning was trying to get some folks together to
Okay,
shed some light on it.
okay, and then Mr. Johnston will be a plea?
Yes, sir.
I hear him say that, okay. All right, so I'm gonna stand in recess. I'm gonna go help Ms. Abraham with the paperwork on Mr. Madrano and Ms. Prox. And we'll see if Ms. Hampton shows up. All right, so court will stand in recess. Are you ready on Mr. Johnston?
Yes, Judge.
Mr. Johnston, come on up, sir. This is cause number CR 23-163, State of Texas versus John Henry Johnston. Mr. Johnston, sir, you'll raise your right hand. I'm going to place you under oath. Do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, thank you. You can lower your hands. All right, your name is John Henry Johnston, is that correct?
Yes, sir.
And Mr. Johnston, are you a United States citizen who reads, writes, and speaks English?
Yes, sir.
Have you ever been diagnosed with a mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Jonathan Manning. Are you pleased with Mr. Manning and the work he's done for you as your attorney?
Yes, sir.
Do you have any questions about the paperwork or your case or anything else before we go forward?
No, sir.
Okay. Mr. Manning, do you believe your client, Mr. Johnson, to be competent?
He is, Judge. During the course of our representation and in preparation for trial, he was able to sit down with me, interact with the discovery, prepare defenses, engage in conversation regarding his case. And I believe his waiver of those defenses and his entering into a plea today is done intentionally, knowingly, and voluntarily.
Thank you, Mr. Manning. All right, Mr. Johnson, you were originally indicted by the grand jury with a second-degree felony offense of aggravated assault with a deadly weapon. I see today that the plea agreement between you and the DA's office is they're recommending that the court consider the evidence and allow you to plead guilty to a lesser included offense, a lower offense of a Class A assault causes bodily injury. They're recommending that your punishment be assessed at 97 days in the county jail, with you receiving credit for that 97 days that you've already served. In addition, they're recommending a $250 fine. The range of punishment for a Class A misdemeanor is confinement in the county jail for not more than 365 days and a fine not more than $4,000. Understanding the plea agreement and the range of punishment, Mr. Johnston, I would ask you, how do you plead to the Class A misdemeanor offense of assault causes bodily injury?
Guilty.
Are you pleading guilty to that crime because you are in fact guilty of committing that crime?
Yes, sir.
Has anybody threatened you, forced you, or pressured you to plead guilty?
No.
Court does accept the defendant's plea of guilt at this time. Mr. Manning, any objection to the stipulation of evidence?
No objection as offered, Judge.
All right, the stipulation of evidence is admitted and the court does take judicial notice of the defendant's judicial confession. Anything further from the state?
Your Honor, only that state is in compliance with victim contact, but victim impact statement was sent out and not returned.
All right, thank you, Mr. Harwell. Anything further from the defense?
Nothing from defense, Judge.
All right, I do have a question. I think his original indictment included a deadly weapon allegation. I don't see any kind of weapon disposition in this plea. I know that the whichever agency is holding this weapon is going to be inquiring about whether or not they're to return it. Is there an agreement on that?
Your Honor, I believe the weapon actually belonged to a co-defendant. And I believe the disposition was in that case.
Okay.
I can double check though, and if a nunk is going to be required, we can probably work that out.
Do you know who the co-defendant is?
I can look it up real quick, Your Honor.
Judge, if I may, actually, I believe at least one of the seized items was, in fact, my client's. And our understanding was that was going to be returned to him at the disposition of this case. I've explained to him the policy of the sheriff's office that he has 30 days from this time of judgment to go pick up his property. Additionally, Judge, there was a truck that was on Mr. Johnson's property that was seized as evidence as part of this case. I've been unable to track down that disposition, but I've told him that once the case is complete, he can take the paperwork to the sheriff's office and request receipt of those items.
Okay. All right, court at this time is going to review the evidence. All right, court finds that there is enough evidence to convict Mr. Johnson of this offense. The court will follow the plea agreement. Court hereby convicts John Henry Johnson of Class A misdemeanor assault causes bodily injury, assesses his punishment at 97 days confinement in the county jail, issues him credit for 97 days time served, orders him to pay a $250 fine, $270 court cost, $535 in reimbursement fees. Mr. Johnston, are you going to be able to pay those financial obligations today, or are you going to need a payment plan?
Judge, if I may, he has credit for $800 based on his, very, regular pretrial, payments. And so, I did confirm that on the court cost sheet, he does have $800 credit. Miss Peggy said she will, get with him after court to, discuss settling on the remainder of the balance.
Okay, so he'll have about
About two.
$265 credit towards $520.
I think he'll have about 200 remaining, 250 remaining.
Well, his reimbursement fees alone are $535, so that's, the majority of that's gonna be taken out by that, so that's only gonna leave him $265 left, and then he'll have $250 fine and a $270 court cost, so he'll have $520.
Judge, as I said, I think, Miss Peggy was able to provide, the court cost sheet, and I think once we complete court, she's gonna apply those credits and
Okay.
talk about those remaining balance.
Mr. Johnson, you hereby remain into the custody of the sheriff, so he can carry out the terms and conditions of the sentence. I'm gonna have you come forward to be fingerprinted with Deputy Martinez. And then if you want to stick around, we'll give you a copy of this for your records. Connor, are you ready? Come on up. This is cause number CR 24-218, State versus Isaiah Alexander Madrano. Court has set Mr. Madrano for arraignment today on the charge of evading arrest or detention with a vehicle, a third-degree felony. Court has found that Mr. Madrano is indigent on his application for court-appointed counsel. Court finds him to be indigent for the purposes of the Sixth Amendment, has appointed the Honorable Jonathan Manning as counsel. Mr. Manning, are you ready for arraignment?
Yes, Judge, we have had an opportunity to go over the indictment. My client's name is spelled correctly. He understands the charge against him as well as the range of punishment. At this point in time, pleads not guilty and requests to be set on the pretrial docket.
All right, the court does enter Mr. Madrano's plea of not guilty into the record. Finds that he does waive the formal requirements of arraignment. Court sets this matter for pretrial hearing. Do you want that December 3rd date, Mr. Manning?
Judge, that'd be fine.
Court sets Mr. Madrano for pretrial December 3rd. That will be at 9 a.m.
Thank you, Judge.
The court finds that Mr. Madrano has already signed his conditions of pretrial release.
Judge, may Mr. Madrano be excused?
Yes, ready to go.
Next, Judge, ready on Miss Prox.
Ms. Brox, come on up. This cause numbers CR 24-220, CR 24-221, State versus Gina Lynn Prox. Court finds Ms. Prox has requested court-appointed counsel. Court, upon review, finds that she is indigent for purposes of the Sixth Amendment and has appointed the Honorable Jonathan Manning as counsel. Mr. Manning, are you ready for arraignment in each case?
Yes, Judge.
Go ahead.
Judge, I have gone over the indictments with my client. Her name is spelled correctly. She understands the charge and range of punishment in both cases and pleads not guilty at this time. Request to be set on the pretrial docket for December 3rd.
All right, court enters Ms. Prox's plea of not guilty into the record for each charge. Finds that she does waive the formal requirements of arraignment, sets pretrial December 3rd, 2024 at 9 a.m. The court finds that she's already signed her conditions of pretrial release.
It should be excused.
Not quite yet. Ms. Prox, what are you emotional for?
Judge, when I spoke to her about the allegations. There was a punishment enhancement on her case that changed the range of punishment. That was a bit shocking to her. I explained to her the law and told her that, no matter how far back, the state can judge up your past and use it against you in the future, so.
Yeah, that is something to be quite concerned about, Ms. Brox. I'll tell you something else to be quite concerned about. Being on methamphetamine and marijuana and walking into this courtroom,
I'm not on it today. It was,
well, you
Sorry.
took it a few days ago, so it's still in your system. And if you're taking it a few days ago, you're probably likely to take it in the next few days. And if you do, and you come back here and I drug test you and I catch you using methamphetamine, marijuana, or any other way violating those pretrial release conditions, I'm gonna find your bail insufficient. And I'm gonna put you back in jail. And these prosecutors sitting over here, they can use that against you towards that big sentence that Mr. Manning just told you could be possible. So it's time to sober up. It's time to have a life check and figure out what you're gonna do. So I'm not gonna put you in jail today because you hadn't signed the conditions of pretrial release, but today you're on notice that you gotta be done with that. If not, I'll have to do my job, you understand? And you will not make Mr. Manning's job any easier if you don't comply.
yes,
You understand?
yes, sir.
All right, you're free to go.
Next, Judge, ready on Mr. Jaquavian Jackson.
Mr. Jackson, come on up, sirs. Cause number CR 21-361, State versus Jaquavian Antron Jackson. Motion to revoke. Go ahead, Mr. Manning.
Judge, today, state and I have discussed a potential resolution for this case. The state is considering that proposal that we gave. Would ask to be reset for the next evidentiary docket for a final setting on contested motion.
Objection from
State's in agreement, Your Honor.
All right, thank you, Mr. Harwell. All right, court sets Mr. Jackson for a final hearing on the motion to adjudicate. That will be 2 days before Thanksgiving on November 26th. That will be at 9 a.m.
May he be excused.
Yes, free to go.
Thank you, Judge.
Deputy Martinez. I'm gonna have him call Hannah Hampton's name and then that'll. Okay. Do you need the court?
May I approach?
You may, yes. Will you call the hallway for Hannah Hampton, please? All right, the court has called the name Hannah Marie Hampton at 9 a.m. She was not present in the courtroom. Her name has been called loudly and distinctly 3 times in the courthouse with no response. Court hereby issues a judgment nisi and alias capias. All right, that does conclude this morning's criminal docket. We will resume at 1:30 with in-person hearings from the Van Zandt County inmates from the Van Zandt County Jail. And we will be having it our way today. See y'all out there.